Good day and welcome to Home Times. Does an owner in a sectional title complex have the right to ask a general item at an AGM that was not included on the agenda originally? Today we're chatting to Kimry Ritchie. She's part of SSLR Incorporated, an attorney firm based in Johannesburg and Cape Town. Kimry, what is the correct course of action for a person wanting to raise a general item at an AGM?
So I think it depends on how strict your body corporate is, if I could use that word in the typical sense. An item raised in an AGM is supposed to be on the agenda. All people who will attend the AGM would generally get the meeting minutes before the AGM, so they would know what is going to be spoken about. Should they wish to raise an additional point, they can advise the body corporate or the trustees of it prior so that it can be raised as a set part of the agenda. However, some body corporates are very strict and they won't allow you to raise anything that's outside of the agenda, but I think you could take your chance and see how lenient your body corporate is and whether they would allow you to discuss it.
Okay, but the correct course of action is to list it as you get the minutes as a course to bring it up as a topic. But if you're in the meeting and you didn't get the minutes, or you forgot, or you were not included, whatever the case may be, and you're at this meeting, at the general meeting, see what the atmosphere is like, and if you think you can ask a general question, then definitely ask your general question.
Exactly, yeah. So advise the body corporate prior to the AGM that you would like this to be discussed as a point. If they forget or if you forget or something along those lines happens, then it's definitely worth a try to see whether they will allow you to raise it.
Great. And a second question we've received from one of our readers, Etienne. He raises a long question, but I think it's very important because he's asking the differences in terms of the way people are referred to in share scheme and community living, the differences between directors, executives, trustees, and body corporate. Maybe if you can just touch on what those aspects all mean, and then we can actually go into the question of what his concern is. So what is a director, and how does that apply in which instances?
No problem. So there is a differentiation between a body corporate and a homeowners association. A homeowners association is run in terms of the Memorandum of Incorporation, so it's registered in terms of the Old Companies Act, which is why the general leader, if you could use that word, would be referred to as the director. So in a homeowners association, there won't be any trustees, there's only directors. Then in a body corporate, which is separate to a homeowners association, any owner in a body corporate is referred to as a member. So if you're an owner, you're automatically a member. Then members select who would be a trustee. So a trustee is in charge for a body corporate and a director is in charge for a homeowners association. And now in terms of the new legislation governing the sectional title law, one is entitled to appoint specifically an executive managing agent. So in that sense, that's who would then be an executor or an executive. Yes. So you wouldn't generally just get an executive in a body corporate. They have to specifically be employed as such, and that's where they would get their title from.
Great. Okay. So this is the question. Because of, I think, what happens in the media, and we are probably to blame for this too, because we form part of the media, there's a lack of consistency and uniformity as well as in Joe Public when people refer to these aspects and these people who represent those roles. People don't always maybe use the correct terminology. So if there's a dispute referral that's necessary to go to the ombud or go to a court, and the complaint is brought in the incorrect representation, so the claim is brought against a director, but it might actually be in terms of what sectional title law is being broken, or there's been a breach. Can that, because the person was referred to as the incorrect designation, can that be thrown out and basically you need to go back to square one? Or is it okay to be overlooked in terms of the legislation and the way it's carried out in courts and in the tribunal?
I believe it's very important to refer to the correct person if you are taking any form of action, be it through CSOS with the Ombudsman or through a court of law. Because of the differentiation as to what a specific, either a member or a trustee, they have different rules and responsibilities. So if you refer to the person incorrectly, I think it could be quite problematic. Obviously, there's always recourse if you do make a mistake. There's ways to go around fixing those mistakes, but you do need to refer to the correct person in their correct capacity.
Fantastic. Kimberly, I want to thank you so much for your time. Thank you for joining us. If you've got any questions regarding sectional title, living and law, please feel free to leave us a comment or email me at david@hometimes.co.za.